9 News legal analyst Whitney Traylor joining us now just to lend some perspective. Whitney, thank you for being here. I think the conversation that a lot of people are having, not really understanding how self-defense really plays into this specifically when it comes to the defense laws in Wisconsin. Can you kind of explain what happened there?
Yeah, it's tough to imagine. And so the law in Wisconsin is very favorable to a defendant claiming self-defense. So the prosecution had to affirmatively disprove self-defense beyond a reasonable doubt. And so if the jury goes back and had some reasonable doubt, then they're going to return a not guilty verdict. And that appears to be what happened. And so Wisconsin law allows the use of deadly force only if it's necessary to prevent imminent death or great bodily harm. And some people are criticizing the law because it focuses just on that moment. When you create the danger, there is no self-defense. So in this case, the victim threw a plastic bag with toiletries at Rittenhouse, and that's when the shooting happened. They said he went for his gun. Now, the prosecution argued, well, he created the conflict by going there in the first place. He came from a small town in Illinois. And the prosecution actually showed video of him pointing the gun at folks earlier before the shooting. And so really, the criticism here is that this sets a dangerous precedent for vigilantes who may feel empowered to travel anywhere to protest, to any protest, provoke attacks, and then shoot people claiming self-defense.
I want to go back to the trial and how this has played out because so many of us have been glued to it and kind of these unorthodox methods that we've seen specifically by the judge. Just how he was handling this guy with kid gloves. Is that unusual?
Well, I thought it was unusual. I mean, there were a number of things that this judge did that were unorthodox. Some people said, well, he's a senior judge. He's kind of set in his ways. But for example, he called for an applause for a military veteran right before he was about to testify. He was a defense witness. So, and had everybody in the courtroom clap for this person. He also had, many people saw Kyle Rittenhouse actually draw the juror numbers to determine which 12 jurors would make the decision. And, the judge said, well, this is my practice, but there were a number of attorneys who said, I've been in front of that judge before, and he's always had the clerk pull those, not the defendant. So, the other thing you pointed out how he handled Kyle Rittenhouse with kid gloves, and conversely, he went after the prosecutors. And he was aggressive with them at times. I thought it was appropriate based on prosecutor conduct, but there were other times that it seemed to be a little excessive. And I'll tell you, as a trial attorney, one thing you want is the jury to be with you, to trust you. And the way they do that is they're taking cues from the judge. When the jury comes in, they're as nervous as everyone else. And the one person they're going to trust and look to is the judge. So if the judge appears to be, biased, I won't say quite that strong, but, the judge's tendencies, they're going to follow that. And I think that was reflected in this trial.
And I want to ask you just a very direct question, maybe one I shouldn't, but when it comes to the polarization, not only of this case and now obviously the verdict, can we ignore the fact that race played a role in this?
I don't know that we can ignore it. I mean, this case, honestly, I think this is almost more about gun rights and the Second Amendment in many ways. I'm looking at the defense attorney in September in a TV appearance. He said his client was acting in self-defense, but he said he was also a courageous defender of liberty and a patriot who exercised his right to bear arms amid rioting. And so they claim that Rittenhouse is being sacrificed by politicians really who want to strip citizens of the right to defend their communities. So I think that they've sort of framed this almost in a Second Amendment way. And I think this case, it shows the legal plausibility of Rittenhouse's self-defense claim, but it completely illuminates and illustrates, the difficulty of reconciling mass gun ownership, expansive rights to self-defense with our rule of law. So I mean, honestly, this is, in a way, this is an extension of the Trayvon Martin case. How do you create the danger by following folks, by going to the situation and then claim self-defense? So I think these are conversations that we need to have, we are having, and it does call into question the system. This is one verdict, but you have to look at the system as a whole. And for this verdict to come out when he went there, claiming to want to protect property and things, we have to look at the system.
Mm-hmm. I think regardless if you agree with this verdict or not, that maybe is the takeaway today, is just to really reflect on our justice system. Is it working? And what happens the next time a case like this arises, because as history proves, it will. Whitney Traylor, thank you.